Welcome to Strategic Justice in Action with David Senoff.
Hey everybody, welcome back to an all-new episode of Strategic Justice in Action with David Senoff, founding partner of the First Law Strategy Group. I'm your host, Mike Leon. David is a plaintiff's attorney focused on appellate advocacy, insurance bad faith, and public policy litigation that holds corporations and governments accountable. And in today's episode, we're talking about how a single lawsuit can do more than resolve a dispute. It can change the rules that shape entire communities. David, it's good to see you as always. You've handled these cases that go beyond individual disputes and aim to change broader policies. I want to ask you, what distinguishes a public policy case from a traditional civil lawsuit?
Hi, Mike. Good to be here with you as always, and thank you for that question. A lot of public policy lawsuits focused on corporate action, like you talked about, or corporate defendants, involve what they call mass torts. So, for example, Monsanto and the Roundup litigation has been in the news lately because of the alleged link between using Roundup and breathing in the fumes and getting leukemia. And in that lawsuit, what will end up happening is obviously there will be individual plaintiffs, but there may also be a change either in the sale of Roundup or maybe pulling it off the market, whatever the case may be. And that's really what a public policy case is. Now, a public policy case against a government entity, for example, we were involved with what became known as the Kids for Cash cases here in Pennsylvania, where two judges had received money from some private prison corporation in exchange for closing the publicly funded juvenile prison, and sending all of the juvenile detainees to the juvenile detention center that was owned by the corporation that was giving them money. And so for a period of time, many, I believe it was 4.5 years, many juveniles were adjudicated delinquent and sent to the prison under suspicious circumstances where they may or may not have been guilty of the alleged offense, but they went to juvenile detention in any event because of this, sort of conspiracy that was going on in the background. And so that's another example of public policy litigation. We were not involved in the criminal aspect because, trust me, there was plenty of criminal aspect of that case. But afterwards, we were involved in representing the families and the kids who ended up in jail wrongly.
Once it's clear in that scenario, for example, once it's clear the outcome could influence, let's say, future policy, how does that change your litigation strategy? Does it change your litigation strategy?
I like to say that these cases are really the same as an individual case with a couple extra motions. But if that were true, everybody would do it, sort of. So from a legal perspective, you have to treat them, right, like a regular case, because there's just some things you have to do in every single case. But you can't just treat them like a regular case, because you have to recognize that these are issues that affect the everyday lives of many, many, many people, and also affect, in that case, elected officials. We had a case that we sued the former governor of Pennsylvania about maintaining, at the time, this was well before the Affordable Care Act, what Pennsylvania called adult basic care, which was sort of like the Affordable Care Act, only just for people in Pennsylvania. And they wanted to defund it. And so we sued to maintain the funding. Now, we didn't sue for everybody who was receiving those benefits, but we knew in the back of our mind that while we were litigating the case for our clients, that it was going to affect a substantial number of people in Pennsylvania, whether they were part of the case or not.
Let me ask you, I've heard a bunch about bigger cases like lead paint or opioid litigation. How do counties or funds decide whether to take legal action rather than wait for the legislative process?
So a lot of times, particularly in those kind of sort of public pollution or public nuisance cases like opioids or lead paint, counties will recognize that they have a substantial problem, right? I mean, there was the story about the opioids, I believe, in a county in West Virginia where I think they had bought and sold enough opioids for something like 4 times the amount of the population of the town, right? And clearly that was a problem and nothing could be done. Similarly, in lead paint, a lot of times counties will have remediation programs to help property owners and buyers, defray the cost of remediating lead paint. That's very expensive, right? If you have lead paint in your house, to get it either stripped off or sealed properly is an expensive, time-consuming effort. But the flip side is that if you don't do it, right, and you have small children, it's a real huge public health hazard. So what'll happen is the counties themselves will try and get help from the state and the federal governments. And when that fails, they turn to trying to get satisfaction in the courts. And, they're not quick to act, right? I mean, they understand the process. They understand it takes time. But eventually, there comes a point where the crisis gets to be too much for them to handle at a local level without additional resources. And so then they'll file a lawsuit.
Public policy litigation, David, as you know, often involves multiple plaintiffs, even jurisdictions. How do you coordinate that strategy so the message stays consistent while the law develops?
In cases that are like, for example, the opioids cases, right? That was coordinated both on the state level and the federal level, because some cases could be removed to federal court, even though they were filed in state court, and some cases couldn't. And so a judge was appointed. There's a process in the federal court where they pick a judge somewhere in the country, and that judge handles all the federal cases. Similarly, in Pennsylvania, we have sort of a mini version of that rule. And if there turns out to be, hundreds, thousands of cases on the same issue, like opioids, the state has a policy or a process where a judge will be determined through a motion process and to handle all the statewide cases. And then that judge frequently coordinates with the federal judge so that even though some of the cases might be sort of moving at a faster pace, that everybody understands sort of where all the cases are. Generally, they try not to make rulings that are inconsistent with one another. For example, if the federal judge requires a certain amount of documents to be produced, the state court judges try not to issue orders that require different documents to be produced, that kind of sort of logistical coordination. But beyond that, the cases ultimately get tried where they are, either in state court or in federal court, a lot of times one at a time.
David, let me ask you a moral versus legal question here. You're balancing the legal record with the moral weight of the issue. How do you keep the advocacy effective without letting the passion override precision?
So in the Kids for Cash case, that was truly an issue that we wrestled with on an almost daily basis. I mean, when you think about kids going to prison essentially because judges are getting money from the company that owns the prison, it's hard to to envision a set of facts that would pit the moral versus the legal aspects in a better light. It's hard to find a better example of that. And I will say that there were plenty of times, especially at the beginning of the case, where I stood up and I would say at the beginning of every appearance in court, this is a case about children being sent to a detention center for profit, right? And eventually, because at the beginning I would say more than that, at the start of the case, I would really sort of give the judge my closing argument as if we were in a jury trial, until finally the judge said to me, "Mr. Senoff, I know the facts, and so do all the reporters who are sitting behind you," right? So eventually the judges want you, not eventually, they always want you to be dispassionate in terms of presenting argument, but sometimes the facts of the case warrant that kind of passion from the lawyer. And the one thing I will say is it's important to make sure that you save that for the courtroom and not the courthouse steps, because frequently lawyers get themselves in trouble by saying too much on the courthouse steps and not enough necessarily in the courtroom. You always want to balance, as bad as whatever it is you're trying, you always want to balance and temper what you say in court. What you say outside of court with what you say, with sort of an even keel, because many lawyers have had problems later on in the case because of things that they said outside the courtroom. So it is a delicate balance, but it's not easy.
Yeah.
You have to remember your role.
We've seen countless examples of that, that's for sure. Let me ask you then, staying on that, what kind of evidence or even expert analysis tend to carry the most weight in some of these cases that challenge, whether it be corporate, governmental systems?
It's always surprising to me, and this even goes to, you and I talked a while back about insurance bad faith. This even goes to that. Company, you'd be surprised at how much companies, governmental entities, insurance companies write down. You'd be stunned by how much they actually commit to paper, because they don't think they're ever going to be caught, or they don't think that the paper's ever going to be written. And the kind of evidence that you need, it takes a while to get, but eventually you get sort of the internal either emails back and forth. And Mike, if you saw the stuff that people put in email because they think that, it's either A, going to disappear, or B, no one else will ever read it, it's stunning. And so usually the best evidence comes directly from the defendant themselves, either in the form of writing. We've had cases where people were recording their own phone calls. I don't know why, right? Because they're not talking about anything good in the phone calls or anything they'd want to remember. And frequently in public policy cases in particular, like in Kids for Cash, there was a criminal case that preceded the civil case. And so the FBI and the Justice Department and the U.S. Attorney had obtained a lot of evidence, which we were then able to obtain and use in the civil case.
So how does the media attention, we were talking a second ago about the courtroom, the courthouse steps and in front of cameras, how does media attention affect litigation that's meant to potentially drive reform?
So media attention about cases that are meant to drive reform is a good thing, right? I'm not saying that it's a bad thing, because the media attention is what helps drive the reform outside of the courthouse, right? So at the political level, the legislative level, the executive level. But the best thing to do as an attorney is leave that to two people, two two groups of people. One is your client. So if you represent counties, for example, they have communications professionals who talk to the media all the time on staff. Those are the people that should be talking to the press, not the lawyers, not the county commissioners, even though, a lot of them want to take credit for bringing this case, or the law firm or the client can hire a media professional to do that for them, who has good relationships with the press, who can have off the record conversations with the press or on background conversations with the press, so that the press can report the context of the lawsuit, not just a lawyer standing on a stage or a courthouse step, bellowing all this legal mumbo jumbo, but to explain, here's the context of the case, here's why the case was brought, and here's what we're trying to achieve. And when you have a professional that's able to do that for you, that really does help drive reform outside of the courtroom. So even if the case is unsuccessful, you shine a light on the problem, and with the right communications help, you can affect reform without necessarily winning the case.
David, as we land the plane here, as always on these episodes, I would love for you to talk about which reforms or precedents have meant the most to you personally because they reached beyond that courtroom.
I would say the Kids for Cash for me was the most, personally, my kids were, that case took a long time, like 10 years to get from beginning to end. And during that time, both of my children were born, and I just kept thinking all the time what the world would be like for them if we weren't able to affect reform. And we were able to affect reform, particularly for that county. There was an overhaul. And when I say overhaul, I mean through the electoral process of county officials who either knew about it or were involved with it. There was a change in the policy of private prison contracts. So all of that really changed the way juvenile justice was handled. And then at the state level, the Pennsylvania Juvenile Justice Commission really started to take a look all around the state at how the criminal justice system was being applied to kids all over. And I think that, for me, was the best result we could have gotten.
David, thanks for the time, the personal stories and insights on all this. Truly appreciate it, as always.
Thanks. It was great to be here.
And thank you for everybody out there listening to today's episode of Strategic Justice in Action with David Senoff. If you want to learn more about David's work over at First Law Strategy Group, do me a favor, visit firstlawstrategy.com today to connect with David and the team. As always, like, subscribe, leave a review and comment, or share this episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.